I'm here with Shaun Hodge, a policyholder attorney. Shaun, let me ask you a couple of questions. How does the proof of loss work in the state of Florida, and is that something that policyholders need to be looking into?
Absolutely. The proof of loss is critical to making sure that your file is properly documented. The insurance company, you file a claim, they'll come out, they'll investigate, but they're really not on any clock. There's no timetables there. Until you submit that proof of loss to them and you comply with your duties after a loss, anything they give you is really them voluntarily providing it to you. Until you document your loss, your estimate, and submit it in a valid proof of loss to the carrier, you haven't really put them on notice officially of your claim. And that's critical to make sure that you properly get indemnified for your loss.
Shaun, in your experience, are most homeowners qualified and experienced enough to prepare their own proof of loss?
Yeah. So in every insurance policy, there's duties after a loss. These are things that the insurance company has written into the policy saying that they don't actually have to perform under the policy until you comply with all these different items, right? And it's a very onerous list of things that you have to do. Most homeowners cannot comply with that. I would say 99% of homeowners cannot comply with that. I have attorneys, I have judges, I have politicians that call me all the time, looking at their policy and saying, I don't know what I need to do. What's my next move? Your next move should be complying with your duties after a loss, and you really need a public adjuster to perform those duties for you, or you need an attorney to get involved. It doesn't need to come to an attorney unless you've had a public adjuster first perform those duties after a loss. There's a time and place for an attorney, but I want the public adjuster to go out there, help assist the homeowners, set it up, give the insurance company an opportunity to perform, and if they don't, then you need to speak to an attorney.
So the insurance company has their own adjuster that works for the insurance company. It only makes sense that the policyholder can hire their own adjuster to work in their best interest.
Right. The adjusters that are coming out from the insurance company, they work solely for that insurance company. Whether they're in-house or whether they're an independent adjuster, it's really a misnomer. They're not independent, right? They're going to do what the insurance company wants them to do. So you need to have somebody that comes in and is going to advocate for you as the homeowner. They look at your loss. They don't work for the insurance companies. They just work for you. They're going to document their loss and they're going to submit it back to the carrier. That's what you need.
We're now approaching almost 2 months since the storm Hurricane Ian hit Southwest Florida. What sort of timelines should property owners be concerned with, problems that they might run into down the road?
Yeah, so a lot of your different policies, if you have a replacement cost policy, you have to either provide a notification that you're going to start making repairs or actually start performing those repairs. And so you need to document in writing, and your public adjuster can assist you with that and putting the insurance company on notice that you do intend to make those repairs. Otherwise, you could lose money under your policy. You could lose that replacement cost value.
What other timelines could be out there? I've seen the RCV policies. Some of them have as short as a 6-month requirement before you let them know that you're going to claim those RCV benefits. What's a standard amount of time, and then how long does a policyholder have to hire an attorney if they would like to do so?
Sure. So before you ever make the decision on whether you need an attorney, you want to make sure that you've complied with your duties after a loss, you've made your property available for inspection, and you've put the ball in the court of the insurance company. And the way you put the ball in their court is to create the proof of loss. And so you need a itemized estimate documenting exactly what you're claiming was damaged from Hurricane Ian. That includes your dwelling, your contents. If you're displaced out of the home, that would be your additional living expenses, your receipts, your invoices. Until you've submitted that complete package, right, the insurance company really doesn't have to act. They don't have to pay you anything legally under their policy. So it's actually on you. It's not the insurance company's responsibility. It's on you as the homeowner to not only file your claim, but make sure that you put the ball in their court with that package of all the information the insurance company needs.
I see. So if the homeowner does that, maybe they hire a public adjuster, but they don't get any progress, and this continues to go on for a year or more down the road, at what point would a policyholder lose their ability to file a lawsuit against their insurance company?
Yeah, so that's going to vary by policy. It's usually called a suit against us clause, or some deadlines with the statute of limitations are involved. But until your public adjuster actually submits that proof of loss, and that ball's been in the court of the insurance company for probably 60 to 90 days, you don't even need to consider bringing an attorney in. But if you've submitted that proof of loss, you've submitted that demand package to them, and you're going 60, 90 days down the road and they're not getting back to you or they're not issuing payments, that's when you need to start looking in, maybe speaking to an attorney to see what your options are under your particular policy.
Shaun, thank you so much for sharing this information with us and with the people of Southwest Florida.
Thank you very much.